Welcome back to the Toy Report. We have some major news to share. A district judge has granted a preliminary injunction against the Illinois assault weapon ban and magazine ban. Additionally, the judge acknowledged the importance of pistol braces in the Second Amendment and criticized the ATF's attempt to regulate them, stating that they are overreaching. This is a significant development. Displayed on the screen is the first page of a recent decision that consolidates 4 separately filed cases with different sets of plaintiffs, all of whom were suing Illinois over their assault weapons ban and magazine ban. I'll share the link in the description for all you two-way nerds out there. Upon reading the decision, it becomes clear that the judge understands the issues at hand and his statements resonate with what many of us believe. It's an impressive decision that could ruffle the feathers of politicians like Jerry Nadler. As always, I know a lot of you dear viewers and subscribers hate lawyer speak, so I'll paraphrase everything for your viewing pleasure. So, let's start on page 2, where District Judge McGlynn introduces the case. He says the court is dealing with 4 consolidated cases requesting a preliminary injunction under Federal Rule of Civil Procedure 65. These 4 cases aim to prevent the enforcement of the state's Protect Illinois Communities Act, or PICA, until the law's constitutionality can be determined. The plaintiffs each filed a motion for a preliminary injunction. On the other hand, the defendants, including Attorney General Raoul, Governor Pritzker, and the Director of Illinois State Police, Brendan F. Kelly, have filed a response to each respective motion that included 14 exhibits. On June 23, 2022, the United States Supreme Court rendered its decision in the case of New York State Rifle and Pistol Association Inc. versus Bruin. One of the key findings of the Bruin decision was that the right to bear arms extends to the ability to carry a firearm for defensive or offensive purposes on one's person, in their clothing, or in a pocket. Shortly thereafter, a group of family and friends gathered in Highland Park, Illinois to participate in a parade, one of the long-standing traditions of America's Independence Day celebration. They came together to honor our country, our freedom, and our liberties. Tragically, during the parade, a senseless incident involving firearms occurred, resulting in the death and injury of multiple parade goers. Months later, the state of Illinois implemented the PICA law. PICA was introduced by its supporters in response to that tragic incident in Highland Park. This law imposed severe restrictions and bans on the sale, purchase, production, delivery, importation, and possession of a wide range of firearms, magazines, attachments, stocks, and grips. PICA was promptly challenged as unconstitutional. As Americans, we should cherish our rights and freedoms, particularly on Independence Day. However, can the reprehensible actions of a small number of people justify violating the constitutional rights of law-abiding citizens in the hope of preventing or mitigating such crimes? More specifically, can PICA be reconciled with both the Second Amendment of the U.S. Constitution and the Bruin decision? This is the question that the court must answer. At this stage, the straightforward response is probably no. Per Bruin and Heller, citizens have a constitutional right to own and possess firearms which they can use for self-defense. However, PICA appears to have been drafted in disregard of the explicit guidelines in Bruin and Heller instead of aligning with them. Whether well-intentioned, brilliant, or arrogant, no state has the power to pass a law that infringes on the constitutional rights guaranteed to its citizens. Even legislation that has the support of a majority of citizens cannot stand if it violates the constitutional rights of fellow citizens. For the reasons outlined in detail below, the overly broad scope of PICA necessitates the grant of the plaintiff's request for injunctive relief. The judge proceeds to explain the requirements for obtaining a preliminary injunction and how the plaintiffs were able to meet those. To avoid all the boring legal mumbo-jumbo, I'll only talk about the juiciest part of the requirement that was met: the likelihood of success on the merits. It is noteworthy, ladies and gentlemen, to pay attention to what this judge says as he articulates a viewpoint that is shared by many of us on one side of the political spectrum, but which very few judges have the cojones to put in writing, as this judge did. The court is now faced with addressing the third issue, which is the likelihood of success on the merits. The plaintiffs rely on recent Supreme Court rulings that have established the protection of possession and use of firearms that are commonly used. They argue that the banned items under PICA are widely used, and therefore, there should be no question of their success in this matter. The Second Amendment states, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. At face value, this text suggests that PICA may indeed violate the Second Amendment. However, before evaluating the parties' arguments and the validity of PICA, it is necessary to review the relevant aspects of the Bruin, Heller, and McDonald decisions. The court must determine whether the plain text of the Second Amendment, as it was originally understood, covers the conduct of the plaintiffs. If If so, the Constitution presumes that such conduct is protected. The defendants argue that PICA does not restrict firearms as they are defined in the context of the Second Amendment. They claim that accessories and weapons that are primarily used in military service are not considered arms according to the plain text of the Second Amendment. However, the defendants do not dispute that the plaintiffs are all law-abiding citizens and, as such, are entitled to the individual right guaranteed by the Second Amendment. Additionally, the defendants do not challenge the fact that possessing the restricted items falls within the ambit of keeping for the purpose of the Second Amendment. The court will first address the defendants' argument that non-essential accessories fall outside the scope of the Second Amendment's plain text. PICA prohibits the possession of a semi-automatic pistol with a detachable magazine if it is equipped with a threaded barrel, a barrel shroud, a flash suppressor, or an arm brace. It also bans the possession of magazines capable of holding more than 15 rounds and fixed magazine semi-automatic pistols capable of accepting more than 15 rounds. The defendants contend that these items are not necessary for the functioning of a firearm and are therefore not considered arms and are not protected by the Second Amendment. However, this argument is not convincing. The Seventh Circuit has recognized that the Second Amendment extends to the corollaries to the core right of possessing firearms for self-defense. It is difficult to imagine something more closely linked to the right to use a firearm in self-defense than the ability to load ammunition into the firearm effectively. The Third Circuit acknowledged the significance of this corollary and held that a magazine is an arm under the Second Amendment. Moreover, the defendant's own expert defines high-capacity firearms as handheld arms capable of holding more than 10 rounds, recognizing that the Illinois statute permits up to 15 rounds for handguns. The expert's definition of a firearm includes magazines. Therefore, this court agrees that magazines are arms under the plain text of the Second Amendment. The plaintiffs are correct in asserting that this is not a close call. If the defendant's expert includes magazine capacity in the definition of a firearm, given his level of expertise, it would be unreasonable to expect the original public meaning of the plain text not to reflect a similar understanding. Let's talk about arm braces. In Ezel, the Seventh Circuit held that Chicago could not prevent law-abiding citizens from practicing target shooting at a firing range because it would impede their meaningful exercise of the Second Amendment right. Similarly, it obstructs the meaningful exercise of Second Amendment rights for another group, individuals with disabilities. For example, consider the use of arm braces on semi-automatic pistols. As previously stated, PICA prohibits the use of an arm brace on any semi-automatic pistol with a detachable magazine without any exceptions or caveats. The Department of Justice has also attempted to regulate the possession and registration of arm braces by implementing criteria for firearms with attached stabilizing braces. However, one key distinction exists. The ATF has acknowledged that these braces are essential for individuals with disabilities to use firearms by stating that the regulation does not impact stabilizing braces designed and intended as a stabilizing brace for use by individuals with disabilities. As demonstrated by reason and the ATF final rule, arm braces are necessary for certain individuals with disabilities to operate firearms effectively. Thus, arm braces are a vital aspect of the meaningful exercise of Second Amendment rights for these individuals and can also be deemed an arm. Conclusion time. The plaintiffs have met their burden for obtaining a preliminary injunction. They have demonstrated irreparable harm with no adequate legal remedy, a reasonable probability of success on the merits, that granting the relief is in the public interest, and that the balance of harm favors them. Consequently, the plaintiffs' requests for a preliminary injunction are granted. The defendants are restrained from enforcing Illinois' PICA until there can be a final determination of the merits as to its constitutionality. It is so ordered, April 28, 2023, signed by Judge Stephen P. McGlynn, U.S. District Judge. This ruling is outstanding, and the judge's decision also acknowledged pistol braces as arms, which is significant. While we all know that pistol braces are arms and are therefore protected by the Second Amendment, the brainiacs over at the DOJ and ATF don't think so. And regrettably, that's all the time we have for today. Please click on the like, share, and subscribe buttons and click on that notification bell too while you're at it. Thanks for watching and have a good one.